For the last 4 years, KITUO CHA SHERIA, the Center for Legal Empowerment, has been organizing public interest litigation colloquiums for public awareness of the new constitution. These colloquiums, held annually, have had adverse effects in the implementation of the constitution and continue to inspire the developments of the same. This year's colloquium, being the fourth, sought to tackle the judicial balancing of competing rights as provided for in Article 24 of the current constitution. On the 4th of December 2013 was the night that saw various advocates convened at the Panafric Hotel for a dinner that marked the grand opening of the 3-day event. After inviting the attendants to an open buffet, the Assistant Director for KITUO CHA SHERIA, who is also a volunteer advocate, Mr. Laban Osoro, called upon Ms. Gertrude Angote to issue her opening remarks as the KITUO CHA SHERIA's Executive Director.
Good evening, ladies and gentlemen. What an honor to sit amongst all of you. I thank you very much on behalf of KITUO for finding time to be here. My name's Gertrude Angote. My middle name, I think, is now known because I have really been announcing it. I've served KITUO as a lawyer from the year 2007, and now I serve in the capacity of the Executive Director.
Mr. Nyaudi, Chairman for KITUO CHA SHERIA, thereafter officially opened the colloquium.
I want to welcome you to this dinner. It's our pleasure to host this fourth now public interest litigation colloquium. Yes, it's the fourth one this year, and we are always happy to have judges take the opportunity to interact with friends from us down back at Kisi, where Maroro comes from.
Justice David Majanja of the High Court was the first to give his presentation, in which he examined Articles 24 and 25 of the new Constitution, giving the judicial perspective of it.
Article 24 constrains the government from violating fundamental rights. 2, the government must always justify its action by evidence. 3, that any limitation is justiciable. It is not beyond the court. And I'm happy to say one of the cases I did was one for KITUO CHA SHERIA, refugees.
He was immediately succeeded by Honorable Justice Mary Ngawa of the High Court with her topic on rights adjudication, where she gave her recommendations on the way forward in adjudicating of competing rights.
Everything Adolf Hitler did in Germany was legal. Everything the Hungarian freedom fighter did in Hungary was illegal. It was illegal to aid and comfort a Jew in Hitler's Germany. Even so, I am sure that had I lived in Germany at the time, I would have aided and comforted my Jewish brothers. Now, what I'd like to just bring out is that Martin Luther knew the law. The law was passed, no marching, no this, no that. Blacks must be separate. He went and disobeyed the law. So although the law is there, this is disobedience to the law, because what I believe in my conscience that I am doing is actually correct.
Other guests included Justice Grace Nzioka and Justice Grace Mombi, who expressed their excitement in the colloquium as a way to advocate for human rights.
Now, when I was a board member of KITUO and a volunteer, I remember part of our, I think we used to call them core values, our niche, and I think we used to speak about fighting for justice for the marginalized. And I remember our areas of focus used to be land, labor, and housing, isn't it? So when I read the new constitution and when I look at it today, I'm very excited because in a sense, the things we used to dream about in the 80s and 90s, in a sense they're here because we have a constitution that talks about these things that we used to talk about.
I think if we embrace the new rules, the civil procedure rules, and the Constitution of Kenya 2010, then we are game short. Why are we game short? Because they have opened up. They have opened up litigation. They have, one of the things I know is that the local standard is now open, something that was not there. So you don't have to be personally injured. Your right does not have to be personally infringed for you to move the court. So any one of us who feels that a right has been infringed is now at liberty. We need to embrace it.
Finally, the Executive Director for KITUO CHA SHERIA, Ms. Gertrude Angote, gave her closing remarks for the night.
What do you and me do to ensure that we have at the top level the respect for the rule of law and upholding the judiciary, the institution of the judiciary, because disobedience and contempt of court orders waters that all out what we have been saying, what we have been building, the confidence in the judiciary. So we are very glad whenever we host these events. We have made it a deliberate culture of KITUO to actually host a judge's dinner or a judge's cocktail, sometimes a judge's round table without a drink before we go into this discussion, so that we also hear the mind. Without the bench, we cannot have the success in the public interest that we expect to have. But at KITUO, we continue to welcome each and every one of you, together with your contemporaries and even the young lawyers that are being mentored, to come and work with us. We now have ventured, and Chairman has talked about it, into justice centers within the prisons, but justice centers again within the communities, where we have paralegals engaged in resolving disputes, even within the community.
The second day of the colloquium saw even more attendance. And without any delays, the moderator, Mr. Labanusoro, invited Mr. Nyaudi, alongside Chairman of the Law Society of Kenya, Mr. Mutua, who went on to define the roles of advocates in public interest litigation.
The first thing you need to be alive to is that you need to identify the right case for public interest litigation, then preparation. Most of the times, public interest litigation is faced with a challenge that you face either organizations or government or institutions which are well prepared in terms of their defenses. And unless there is adequate preparation on our side in public interest litigation, what will happen is that you probably file a suit on public interest litigation, then you will meet very well prepared lawyers from the opposition or from the defense side.
Thereafter, Veronica Mwangi, an advocate with the Kenya National Human Rights Commission, took over with a statement which she read on behalf of Ngugi, chairperson of Kenya National Human Rights Commission, giving her oversight of the presentation.
First and foremost, I wish to state that the Commission, since its inception in 2003, we have seriously taken our mandate of holding the government accountable and ensuring adherence. when it comes to realizing human rights in Kenya.
Mr. Nyaudi expressed a lot of concerns of the Persons with Disabilities Act, which he felt required improvement.
Soon after that act was promulgated, a friend of mine who is visually impaired came to me and said he wanted to import a vehicle. Those of you who have looked through that act will recall that in the schedule, the second schedule to the act, any person with disability is allowed to import a motor vehicle for personal use. That is the definition in the schedule.
He acknowledged the importance of the public interest litigation as a tool of advocating for the poor and enhancing the capacity of advocates.
But I came to learn only 5 years ago, having been in practice for many years, that there is value in taking expert opinion, expert evidence on a matter that is not basically a legal issue.
The second part of the day was moderated by Mr. Jude Ragot, a volunteer advocate with KITUO CHA SHERIA based in Kisumu, who went ahead to welcome Professor Ghai with her presentation, where she traced the origin of competing human rights claims, citing various possible dilemmas in balancing them.
What Article 24 does is to call for a two-stage process. Question number one is, have somebody's rights been violated? And question number two is, if somebody's rights have been violated, then is there some justification for that within the structure of Article 24?
After a brief lunch break, Mr. P.J. Otieno, also a volunteer advocate with KITUO CHA SHERIA, called upon John Chigiti, an advocate of the High Court, to give a general overview of Article 24 and 25 of the Constitution.
Before a right can be controlled or limited, other factors must come into play. The judicial officer or the party limiting the right has to ask, what is the nature of this right offering? What is the relevance or the importance of limiting that right? And what's the nature and extent of that limitation?
Thereafter, Professor John Sihanya, a lecturer of the University of Nairobi, cited emerging jurisprudence on Article 24 of the Constitution in relation to balancing of the competing human rights.
The language of balancing is normally that your rights at the end of the day are not absolute. They must be balanced in accordance with either the formula in 24 or formula in 21 and other clauses. Balanced with other broader public interests or right of other or the long list that we have been given in 24. Which means that a balancing act is necessarily a limitation.
The 6th of December was a day to be forever commemorated in history, not because it marked the last day of the colloquium, but rather as the day that Nelson Mandela, a hero and a freedom fighter, rested in peace.
As we mourn the death of one of the heroes of freedom fighters, Nelson Mandela, I think we can stand up. He's the guy who started the public interest litigation in South Africa. Just observe a moment of silence.
First to moderate the day was Mr. Anthony Mulekyo, a volunteer advocate with KITUO CHA SHERIA, who, after observing a moment of silence for the fallen hero, went ahead to invite the director for Katiba Institute, Mr. Waikwa Wanyoike, to compare the Kenyan Constitution's Article 24 with the Canadian and South African versions.
So the first question is, why did they do that? And the quick answer is that it's the type of political arrangement they have. The political arrangement we have here is one that the Constitution is supreme. However, in Canada, they inherit the British political arrangement, which recognizes the supremacy of Parliament. And I have a very simple formula, which is limitation is equals, and this is in a Canadian context. I'm mixing the issues just to relate how the Canadian either applies in our case or may be different to our case, so that people know that. And in the Canadian situation, limitation is equals prescribed by law plus demonstrably justified in a free and democratic society.
After quite a thrilling session, Mr. Wanyoike later divided the attending advocates into two groups and presented a case for them to debate upon. This was moderated by Mr. Justice Munyithia, a volunteer advocate with KITUO CHA SHERIA. Arguing for the petitioner was Group 1, which was represented by Caroline Kasoa, a volunteer advocate with KITUO CHA SHERIA.
Komi and any other person in that community who does not profess religious belief is already discriminated by the way the regulations have been couched, that every meeting under the NKI starts with a word of prayer.
And for the government was Group 2, represented by Mr. Kanyonge, a volunteer advocate with KITUO CHA SHERIA as well.
My Lord, Article 29 of the Constitution that talks about the right to freedom and security is one that is of concern to us. And in fact, this statute is meant to give effect to this right. And that is the reason why we are limiting the right.
After quite a heated and interactive session that saw both teams display their arguments, Mr. Sam Akwale, a volunteer advocate with KITUO CHA SHERIA, came in just in time to welcome Mr. Charles Kanjama, an advocate of the High Court, with his presentation on balancing of competing rights from the judicial perspective.
When you go to court to affirm a right, you meet a respondent who is affirming either a different right or is affirming that your right does not extend this way. So they are trying to either limit your right or affirm another right in contradistinction to your right. So that the concept of conflicting rights narrative is always present when you're in court.
Finally, the 3-day colloquium adjourned, having comprehensively looked into Article 24 and critically analyzed and compared most of the rights and how they correspond.